The Honorable Judge Atkinson presiding.
Thank you, everybody. Please be seated. Everybody take just a second, make sure your cell phones are turned off. You can have them on, but just make sure they don't go off as far as a ringing noise. First of all, I'd like to welcome everybody here today. This is the Windsor Wildcats, I'm understanding, and this is the second mock trial that y'all have had. We've got some new faces out there, some familiar faces. We're very glad to have everybody here. I think we're ready to go ahead and get started. Is that right? My understanding is that there may be a motion in this case. Is that correct?
Yes, sir.
All right, let me do this. Let me call the case. This is State of South Carolina versus Peyton McKenzie. It's case number 2025 GS 18-1103. It's my understanding that Ms. Peyton is charged with 3 counts: burglary second, a computer crime act, and entering a public place with the intent to commit a crime. And the motion was filed with this court on May 4th, 2026. It's a motion that purports to have the evidence seized from the locker deemed inadmissible. And so this is the defense motion, and let me do this if I could before we get started. Let me know if we could start from, let's go from here to here. If you don't mind giving me your full name, going from here all the way across, I appreciate that.
Dallas Taylor.
Mr. Taylor, all right. And you are?
Madison Graham.
Graham, all right. And then we have our defense team over here, is that
The
right?
fence is over here.
Defense is over here, and then the prosecution's over here. All right. You are?
Ari Kent.
Kent, all right. Good to have you.
Kaylee Brown.
All right.
Joel Gajadar.
Spell that last name for me.
Gajadar.
Gotcha. Thank y'all so much for being here. I'll tell y'all this before we get started. The hardest part of all this is what y'all do. You understand that? Just being here is a really big deal. So we're gonna have fun with this, but we're gonna take it very seriously because it is a real trial we're doing today, okay? We've got somebody that's been accused of some crimes. We gotta take that very seriously. But what y'all are doing is great work. I've talked to Deputy McFarland, and she has told me the effort that y'all have put into this, and I can't wait to see how it all shakes out. So with that being said, I'm happy to hear from whoever wants to go first from the defense to argue the motion about the locker information. Tell me what's going on.
Yes, Your Honor. May it please the court.
Yes, sir.
We have a motion to suppress the gloves found in our client Peyton McKenzie's locker. In this case, Norman French searched the locker, but the prosecution might argue that New Jersey v. TLO says searches in school are lawful, but the admin searched TLO's purse in that case. Investigator French violated our client's Fourth Amendment right, which protects us against unreasonable searches and seizures when he searched our client's locker without a warrant.
Thank you, Mr. Taylor. Anything further from the defense? Prosecution, if you'd like to respond to their motion.
Yes, sir. May it please the court.
Yes, ma'am.
Your Honor, the prosecution believes that the investigator had the right to search the defendant's locker. The evidence shows that Ms. McKenzie changed her grades and vandalized the school, which is a very serious crime. New Jersey v. TLO gave permission for school searches. The principal called the police and invited Investigator French to the school because a crime was committed.
Very good. Thank you very much. Anything further from the prosecution? Okay. Defense, it's your motion. You have the last word if you'd like to say anything further about the case. If not, that's fine too.
You have to
Everybody's
use your
good?
words, remember?
No, yeah.
Okay. So we're relying on TLO versus New Jersey. Is that my understanding? Y'all have familiarity with that case? Is that right?
Yes, sir.
All right. Well, here's what I'm going to do. I think y'all have both made very compelling and convincing arguments. I have reviewed the applicable case law. What I'm going to do is I'm going to allow the search that was conducted on the locker. I'm going to allow that information to come in. I believe that there is a lesser amount of ability to have a right of privacy for a locker in a school. And so I think you both make very compelling arguments, but I'm going to allow that evidence to come in based on my reading of the case law. I will say that y'all both did a very good job in arguing that point. So for purposes of the trial, understand that if there is evidence relating to the locker, evidence relating to the gloves that may have been found in the locker, I'm going to allow that information to come in. I don't think that there is a heightened expectation of privacy for a locker inside of a school system. So I appreciate y'all's arguments. Anything further before we get started? From the defense?
No, Your Honor.
All right, from the prosecution? All right, I think that we're in a posture in the case where unless there's anything further, we can bring the jury out.
Okay.
Jurors, I turn to you. Good morning. Good morning. How are y'all doing? Good. Good. We are here this morning to try a case. The case is State of South Carolina versus Peyton McKenzie. Ms. McKenzie is in the courtroom. I'm going to tell you a little bit more about that here in a minute. But first, I've got to give you the oath. Can everybody please stand and raise your right hand for me? Stand and raise your right hand. Do you and each of you understand and agree that you will well and truly try the case now pending before this court in a true verdict given only to the evidence presented to you and to the instructions of the court? If you agree, please signify by saying, I do. I do. All right, thank you. You may be seated. Your opening statement, that will be followed by any opening statement that may wish to be made by the defense.
May it please the court. Ladies and gentlemen of the jury, on November 2nd, 2025, a vandalism occurred at Watch Hill High School. School is for learning, not for vandalizing. The defendant vandalized the computer room. Defendant spray painted Isles the Jerk on walls and destroyed computers. Finley Isles gave defendant her very first B, and defendant took matters into her own hands and vandalized the school. At the end of this trial, we are confident that you will return a verdict of guilty on all charges. Thank you, Your Honor.
Thank you. Defense.
May it please the court. Good morning, ladies and gentlemen of the jury. In this case, the investigation started with a guess and ended with a mistake. Our client, Peyton McKenzie, is being charged with burglary, second degree, computer crime, second degree, and a misdemeanor for entering public property for the reasons of destroying records or other property. The actual facts will prove that on the night of November 2nd, 2025, our client was home with her family. The fact of the matter is, there was no DNA, no fingerprints linking my client to this crime. What we do know is that the so-called evidence is based on a flashlight and the word of a teacher who has issues with my client. Listen to the prosecution for the gaps and holes in their investigation. Once you do that, we are confident that we return a verdict of not guilty on all charges. Thank you.
Thank you. Prosecution, you may call your first witness.
We call Finley Isles to the stand.
Let me swear you in real quick. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I swear.
Thank you. You may be seated. Please answer any questions the prosecution may have.
May it please the court. Please state your name and occupation for the record.
Finley Isles, computer teacher at Watch Hill High School.
Miss Isles, how long have you been teaching?
It seems like a very long time, but actually 3 years.
Tell us, what was your reaction when you got to school?
Once I got to the school, I walked to my classroom. I opened the door. I was stunned. My jaw dropped and the stuff in my hands dropped.
When you entered your room, what did you do?
When I entered my room, I walked around. I saw the computer left on, and I checked this previous day log on and day log on.
What did you find?
I found that the computer was accessed between 9:09 and 9:21.
What did you see on the computer?
I saw that Pam McKenzie grade was changed to an A.
No further questions for this witness.
All right, does the defense have any cross-examination for this witness?
Yes, Your Honor.
Okay.
May it please the court. You spoke with Investigator French first, correct? Correct. You told him that you suspected my client, Peyton McKenzie, correct? I don't recall. Was Peyton the only one to ever call you a jerk? No, she wasn't the only one. So really, anyone could have vandalized your room and spray painted the word jerk on the wall?
Correct.
So you really don't know who committed this crime? I don't. Were there any students failing your class? Yes. Did you suspect any of them? I can. So you suspected my client just because she was disappointed about the beat she received from you? Correct. That is all my questions for this witness.
Any further questions from the prosecution and follow-up of those questions? Okay, you may step down. Thank you for your testimony. Prosecution, you may call your next witness if you have any other witnesses.
We call Hunter Cassidy to the stand.
All right. If I could swear you in, please. You raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
All right, you can have a seat. Thank you.
May it please the court. State your name and occupation for the record.
Hunter Cassidy, principal at Watch Hill High School.
How many years have you been a principal?
I have been a principal for about 18 years.
What did the computer teacher tell you happened in her lab the night before?
When Finley Alves told me that her lab was broken into, I was stunned.
What did you do when you saw the computer lab vandalized?
I called the police because I was worried about my students.
What did you do after you called the police?
I walked around the school and see if something else was vandalized.
When you walked around the school, was anything else vandalized?
No, but I did find a flashlight.
Oh, a flashlight. What can you tell us about this flashlight?
The flashlight, it had the code to the students' grades, the same red paint in Finley Alves' computer lab, and the initials PM.
PM? Who initials your PM?
Peyton McKenzie.
Peyton McKenzie? You mean the defendant Peyton McKenzie?
Yes, Peyton McKenzie.
I just have one more question. Where did you find this flashlight?
In the grass across from the students' locker.
No further questions for this witness, Your Honor.
Thank you. Cross-examination.
May it please the court. You called the police, didn't you?
Yes.
Then you went around and did your own investigation?
Yes.
Did you find the flashlight?
Yes.
Did you think about interviewing anybody else after interviewing Peyton?
No, because I knew she was the person because she answered so quickly.
Yes or no?
Yes.
So you already thought my client was guilty?
Yes.
That's all my questions for the witness.
Thank you, sir. Any follow-up to those questions from the prosecution? No, you're good. All right, you may step down. Thank you. Any further witnesses from the prosecution?
We call Investigator French to the stand.
Okay. Ms. Skip French, if you'd raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. You can have a seat. Please answer any questions the prosecution may have.
May it please the court. State your name and your occupation for the record.
My name is Norman French, and I'm an investigator.
How long have you been an investigator?
I've been an investigator for 13 years.
Why were you at the school that day?
I was at the school that day because the principal called saying her school was vandalized.
Investigator French, when you got to the school, where did you go?
When I got to the school, I went to the computer lab to see the vandalism that occurred.
Investigator, what did you do when you got to the computer lab?
When I got to the computer lab, I looked around. I saw the words "Arlos is a jerk" written on the walls. I also saw that computers were smashed.
What did you do after the computer lab?
After the computer lab, I went to the counselor's office to get Pam McKenzie's locker number.
Investigator, why did you get Paisley McKenzie locker number?
I got Pam McKenzie's locker number because all the evidence led to her.
What did you find in Paisley McKenzie's locker?
Inside of Pam McKenzie's locker, I found black latex gloves stained with red paint.
Did the principal present you with anything?
Yes, the principal presented me with a flashlight with a code and the initials PM.
Who initials are PM?
I think they are Pam McKenzie.
No further questions for this witness, Sean.
Thank you. You can answer any questions the defense may have.
May it please the court. You interviewed an eyewitness by the name of Kirby Sinclair, correct?
Correct.
Who saw two people leaving the scene of the crime?
Correct.
Did you bother searching for the other suspect, or did you decide my client was guilty and end your investigation?
I bothered looking for the other suspect.
You searched my client's locker after talking to the computer teacher, Finley Isles, correct?
Correct.
You found gloves in the locker, correct?
Correct.
Where were the gloves in the locker?
One was on the stuff inside the locker. The other one was on the slant in the locker.
Your Honor, I'd like to enter Exhibit 8 in as evidence.
All right, if you'd show that to the prosecution for me, let them take a look. Are there any objections to that exhibit coming in?
No, sir.
No objections? All right, we'll mark this as Defendant's 1, which is labeled on there as Exhibit 8. All right, hand that back to you to use however you may like.
Mr. French, are these open slats on the locker door?
Yes.
So it would be fair to say that anyone could just push the gloves up the locker, given that one was hanging from the slat of the locker and one was hanging on the contents?
Yes.
Did you find my client's fingerprints at the scene?
No.
Did you find my client's DNA at the scene?
No.
So you did not find my client's DNA or fingerprints at the scene?
No.
So you did not. So there was no evidence linking my client to this crime?
But the gloves were in her locker.
Yes or no, sir?
Yes.
That is all my questions for this witness.
Or any redirect from the prosecution?
Yes, Your Honor.
Okay.
Go around.
Investigator French, regardless if the gloves were hanging from a slat or on top of some books, where were the gloves found?
Inside of Pam McKenzie's locker.
No more questions, Your Honor.
Okay. Any brief follow-up to that question? All right, investigator, you may step down. Does the prosecution have any other witnesses?
No, sir. No.
Does the prosecution rest at this time?
Use your words.
Yes, Your Honor.
All right. What I'm going to do at this time is I'm going to hear anything from the defense, but that would be without the jury being present. I'm going to excuse you to your jury room. That will take about 5 minutes roughly. If anybody needs to use the restroom, whatever, the restroom's right back there. I've got to handle some things outside the presence of the jury, and I'll bring y'all right back in, okay? Thank you very much. The prosecution has rested its case, and at this time I turn to the defense. Are there any motions of any sort that need to be heard by this court? Okay. Ms. McKenzie, if you would please stand for me. Ms. McKenzie, you are charged with 3 offenses, 2 of which I believe are felony offenses. You understand that? And you understand that under our Constitution, the laws of our land, you have an absolute right to remain silent, and that you do not have to offer any testimony at all. You understand that?
Yes, Your Honor.
That is your Fifth Amendment right. You have no burden of proof. You have nothing that you have to do. You can remain completely silent if you choose to. Do you understand that?
Yes, Your Honor.
You understand that if you do testify, which is your constitutional right, that the prosecution has the ability to cross-examine you about anything within the scope of questions that they may like to do. And if you subject yourself to that, then you're opening yourself up to whatever there may be out there. Do you understand that?
Yes, Your Honor.
All right. Is it your, you don't have to decide this right now, but is it your desire to potentially testify in this trial?
Yes, Your Honor.
Okay. Just be reminded that you have no obligation to testify and that any testimony can be used against you. Just make sure you understand that. You understand that?
Yes, Your Honor.
All right. You may have a seat. Anything that I need to hear from the prosecution before we bring the jury back out?
No, sir.
Okay. Anything from the defense?
No, sir.
All right. How many witnesses does the defense anticipate calling?
3.
Okay, that sounds good. We'll go ahead. Just need a minute? Okay. All right, all the jurors have returned. Thank y'all for being patient. Let me take just a minute to explain to y'all a little bit about why y'all are excused for that part of the proceedings. There are certain times within a trial where a judge has to make certain decisions about some evidence that could come in or not come in, some rights that may have to be told to certain people, some other issues that don't involve the jury. And what the judge does not want to have happen is the judge does not want to be an influencer of y'all's decisions. So I may make a decision or a ruling or something that's been brought before me by one party or the other that I have to make a decision on. That would be a question of law. Remember, I'm the judge of the law. I have to decide what could come in, what doesn't come in, and I have to make certain advisements to certain people that may or may not testify. So those things are not involving you. Again, y'all are the trier of the facts. You only listen to the facts. Those facts come right here on the witness stand. The rulings that I have to make, anything outside of your presence, has nothing to do with what happens on the witness stand because y'all hear the facts. I'm the judge of the law. Y'all are the judge of the facts. So thank y'all for being patient. We'll now turn it over to the defense. Does the defense wish to have any witnesses that they may wish to call?
Yes, Your Honor. I'd like to call Quinn Page to the stand.
All right, please come forward. If you'd raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Please answer any questions the defense may have.
May it please the court, can you state your name and occupation for the record?
My name is Quinn Page, and I am the school counselor at Watch Hill High School.
Ms. Page, in all the years that you have worked at Watch Hill, has any student ever complained to you about the computer teacher, Finley Isles?
Yes, students have complained to me about Finley Isles, but it was not just students that was complaining. Parents was complaining how their kids experience with Finley Isles, how she makes them do constant work over and over.
Ms. Page, has Peyton ever complained to you about Finley Isles?
Yes, Payne has complained to me about Finley Isles, how it makes her feel dumb and uncomfortable.
Ms. Page, how has your interaction been with Peyton McKenzie?
My interaction with Peyton has been good. She's a very helpful student. She's very smart, kind, and helpful.
How is the security in the front office with the student volunteers?
The security in the front office with all the student volunteers is like cabinets never keep locked. Doors are always open. I mean, really, anyone can just walk in.
Ms. Page, you have stated that the security in the front office is laxed. Do the student volunteers have access to the file cabinets?
Yes, the student volunteers have access to the file cabinets and the adults in the front office.
So only the student volunteers and the adults in the front office have access to the file cabinets.
Correct?
Has Peyton ever volunteered to be in the front office?
No, Payne has never volunteered to work in the front office.
So she couldn't have had access to the file cabinets.
No, she could not have access to the file cabinets.
That is all my questions for this witness.
Thank you. Please answer any questions that the prosecution may have.
Yes.
May it please the court. In your statement, you're not surprised that Payton has a problem with Finney Isles, correct?
Correct?
So you're saying Payton has an attitude problem?
Correct?
So when she doesn't get what she wants, she lashes out?
No.
You stated that the security was lax,
Correct?
and that anyone had access to the front office, even Payton McKenzie?
Yes, everybody else had access to the file cabinets except for Payne because she was not one of those student volunteers.
No further questions for this witness, Your Honor.
Thank you. Any redirect from that? From the defense?
None, Your Honor.
All right, you may step down. Thank you. You may call your next witness.
Yes, Your Honor, I'll call Kennedy McKenzie to stand.
Okay, please come forward. If you raise your right hand for me, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you may be seated. Thank you.
May it please the court. Can you state your name and your occupation for the record?
Yes, my name is Kennedy McKenzie.
And who are you to Peyton McKenzie?
I'm Peyton McKenzie's mother.
What is a typical evening for you and Peyton?
A typical evening for me and Peyton is we watch movies, we cook dinner. Sometimes when she's doing computer work, I look over her.
Where was you and Peyton on the evening November 2nd?
Me and Peyton were at home and Peyton had a friend over.
Can you walk the court through what you and Peyton was doing?
Yes, I was in the kitchen cooking dinner and Peyton and her friend was at the dinner table, not too far away from the kitchen.
Would you have heard Peyton if she left the house that night?
Absolutely. Our house is very old, and if she would have left that night, I would have heard the floors creaking and the door shut.
Did Peyton leave the house at all that night?
No, not to my knowledge.
Did you see Peyton go to bed that night?
No, but I saw her go into the bathroom and brush her teeth.
When did you first learn that the police was accusing your daughter of being at the school?
I first learned that my daughter was being accused of something so vicious like this when I dropped her off that morning and the computer teacher, Friendly Owl, stopped me.
To be clear, your daughter was not at the school November 2nd.
No,
That's
no,
all
she
my
was not.
questions for this witness.
Thank you, sir. Any questions from the prosecution? Okay.
May it please the court. You would do anything to protect your daughter, correct?
Correct.
You testified that you were at home the night of November 2nd with your daughter, correct?
Correct.
Did you have eyes on her the entire evening?
Of course not. Of course I had to go to bed.
So you were with her every hour that evening?
No, I was not.
So you cannot say for sure that she did not leave the house that night, correct?
No, but I could say she didn't leave the house that night because, like I said before, our house is very old, and if she would have
In
left
your
that night,
statement,
I would
Let her
have heard the
answer
floors
that.
creaking
Let her
and the
answer
door
the
shut.
question. Let me answer the question before another question is asked. Go ahead and answer the question.
Like I said before, if she would have left that night, I would have heard the floors creaking and the door shut.
in your statement, you said that you went to your bedroom to read the newspaper. Is that right?
Yes.
So you really weren't paying attention to Payton, right? You were reading the newspaper.
No.
So you cannot be sure that Payton did not leave the house.
Yes, I can be sure.
No further questions, Your Honor.
Any brief follow-up to those questions?
No, sir.
All right, you may be excused. You can step down. Any other witnesses from the defense?
I'd like to call Peyton McKenzie to the stand.
come forward. You raise your right hand. You swear from tell the truth, the whole truth, nothing but the truth. Thank you. Be seated.
May it please the court, can you state your name for the record?
Peyton McKenzie.
Peyton, can you tell us where you were the night of November 2nd, 2025?
I was at home. My friend Marley Morgan and I were studying for our exit exams the next day, and I wanted to spend as much time with her as possible before she left to Europe.
Peyton, can you walk the court through your first reaction to the B you received in computer class?
I was disappointed. Who wouldn't be? But on the bright side, I have all A's, a few A minuses, but even with the B, I still have a 3.0 GPA and I'm on honor roll.
Peyton, so you were disappointed about the B. Do you call Finley Alves a jerk?
I have heard numerous students call her a jerk, but I may or may not have used that language before. She is a really tough teacher.
Peyton, your guidance counselor, Quinn Page, stated that there have been student volunteers. Were you ever one of those student volunteers?
I was not. I feel like I belong in the classroom, learning stuff and helping me with, get me to a brighter future. I think volunteering in the office just doesn't suit me. I don't want to be roaming the halls and doing mindless work.
Peyton, there have been testimonies about a flashlight. Do you own a flashlight?
I do not.
So to be clear, the flashlight that the prosecution is alleged was found at the scene of the crime does not belong to you?
No, it wasn't even my favorite color.
Peyton, would you stoop so low as to vandalizing the computer lab over 1B?
That is beneath me. At a young age, my mom taught me to respect computers, especially with their profession. I would never do such a thing.
Your Honor, I'd like to enter Exhibit 5 in as evidence.
All right, if you show it to the prosecution first, please. Are there any objections to that coming in? No objections? All right, we'll mark this. This is marked as Exhibit 5. We'll mark it as, this will be prosecution's
Defense.
1.
Defense.
Excuse me. That's right, defense 1. Apologize. Defense 2. Prosecution. That was defense 1, this is defense 2. That's my fault. This has been marked as defense 2.
Peyton, can you tell me what you have in front of you?
The request for a new locker combination from 512.
Is that your request for a new locker combination?
It is.
Peyton, why did you request a new locker combination?
Like any 15-year-old girl, I lost my locker combination, and I was just going to go follow protocol to make sure I get a new one.
Peyton, was your request approved?
It was not. I think it got lost because it was not filled out by the office.
That is all my questions for this witness.
Please answer any questions that the prosecution may have.
Miss McKenzie, you're enrolled in Finley's Alves computer class, correct?
Correct.
You expected to get an A, didn't you?
Who wouldn't?
When Finley Alves gave you a B, were you not just disappointed? You're angry, right?
No, I recall I said disappointed.
You called Finley Alves a jerk, correct?
I may or may not have used that language, but I have heard a bunch of other students use that language.
Let's talk about the flashlight found at the scene. You stated you don't own a flashlight, correct?
Correct.
This flashlight was personalized with your initials, PM, isn't it?
Yes, it is, but like I said before, it is not my favorite color. Why would I own a flashlight that isn't even my favorite color?
Isn't it a coincidence that someone put your personalized flashlight at a scene of a crime?
It could.
You claim you were studying with your friend that night, correct?
Correct.
But your mom was the only one who provided an alibi for you, right?
Correct. My friend was study abroad, and like my mom said before, our house is very old. She knew if I left or not.
Did your friend not want to come to court and lie for you?
No,
Objection, Your
Hang
Honor.
on. What's your objection?
Calls for speculation. Oh, wait. No, wait. Your Honor, argumentative.
Argumentative. I'm going to allow a little bit of leeway. Go ahead with your questioning. Thank you.
Did your friend not want to come to court and lie for you?
No, she's focusing on studying abroad in Europe for her academics.
No further questions, Your Honor.
Thank you. Any follow-up questions to those questions by the defense?
No, Your Honor.
All right, you may step down. Thank you. Are there any other witnesses from the defense?
No, sir.
Does the defense rest at this time?
Yes, Your Honor.
All right. Is there anything else I need to hear before we get into closing arguments from either the prosecution or the defense?
No.
All right. It does appear the defense has presented testimony in this case. They have entered evidence in the trial in 2 exhibits. Therefore, the defense will go first, followed by the prosecution in the closing.
May it please the court, ladies and gentlemen of the jury, you heard it with your own ears. You heard it with your own ears. The prosecution's case was filled with gaps and holes. They want you to believe that it is open and shut, that my client committed this crime. Based on the word of a teacher who has issues with my client and a flashlight in a school of hundreds of kids, they want you to believe that my client is the only one that could have had the initials PM. You heard it from their investigator. They did not find my client's fingerprints or DNA at the scene. They found nothing, and they have nothing. Gloves that could have been stuffed in my stuffed in my client's locker proves nothing. You heard it, and I know it. You have no other choice but to find my client not guilty on all charges. Thank you.
Thank you. Prosecution.
Ladies and gentlemen of the jury, a crime occurred that required a specific set of skills. Skills that defendant Peyton McKenzie has. She also had motive. Her motive to keep a straight A average. You heard from Ms. Isles that Peyton had the skills to commit this crime. You heard testimony that the defendant's personalized flashlight was found at the scene of the crime. You were presented with a pair of black latex gloves found in the defendant's locker, stained with red paint from the crime scene. Don't get distracted by the defense's scapegoating theory. You heard yourself. Find the defendant guilty on all charges.
Thank you. All right, is that everything from the prosecution?
Yes,
And everything from the defense?
Yes.
All right. Now it is time to move into the closing instructions that I'm required to give you. Again, this is not a fun part of my job because I have to read you a lot of information. I would just ask that you pay careful attention because this is where it gets into what the law of the case is. I need you to listen carefully as I give you the instructions that you'll use to argue and deliberate in the jury room. Now that all the evidence has been presented, it is my duty under the law to give you the instructions that apply in this case. The instructions contain all the rules of law that are to be applied by you and all the rules by which you are to weigh the evidence and determine the facts at issue in deciding this case and reaching a verdict. You must consider the instructions as a whole. All the testimony and evidence that is proper for you to consider has been introduced in this case. You should not consider any matter of fact or of law except that which has been given to you during the trial of this case. It is your responsibility as jurors to determine the facts from the evidence, to follow the rules of law as stated in these instructions, and to reach a fair and impartial verdict of guilty or not guilty based upon the evidence as you have been sworn you would do. You must not use any method of chance in arriving at a verdict, but must base your verdict on the judgment of each juror. Elements of the charge. In this case, the defendant, Ms. McKenzie, has been charged with entering public building for purposes of destroying records or other property. That law states, any person who enters into any private or public school, college, or university building, or a public building for the purpose of destroying records or other property, or destroys or damages records or other property, is guilty of a misdemeanor. Next, we have burglary second degree. A person is guilty of burglary in the second degree if that person enters a dwelling without consent and with the intent to commit a crime therein. A person is guilty of burglary in the second degree if a person enters a building
without consent and with the intent to commit a crime therein, and either, 1, when it is affecting entry or while in the building or in immediate flight therefrom, he or another person is a participant in the crime. 2, is armed with a deadly weapon or explosive, or causes physical injury to any person who is not a participant in the crime, or uses or threatens to use an instrument of danger, or displays what appears to be a knife, pistol, revolver, rifle, shotgun, machine gun, or firearm. The burglary is committed by a person that doesn't apply to you. The entering occurs at nighttime. Burglary in the second degree is a second charge that the defendant has been charged with in this case. The last charge is computer crime in the second degree. It is unlawful for a person to willfully, knowingly, maliciously, and without authorization, or for any unauthorized purpose, to directly or indirectly access or cause to be accessed a computer, computer system, or computer network for the purposes of devising or executing a scheme to defraud, obtain money, property, or services by means of false or fraudulent pretenses, representations, promises, or committing any other crime. Made to be the foreperson does not give you any greater weight or power. However, it is your decision to bring the jury together and deliberate any way that y'all choose to deliberate. Again, do not knock on the door unless and until you, number 1, have a question that needs to be answered. If you do have a question, I would ask that you write that question on a piece of paper. I will then examine the question and then give it whatever weight I deem appropriate. Or 2, knock on the door when you have a verdict. Again, your verdict must be unanimous. Just because you have 3 verdict forms does not mean that you have to find all guilty, all not guilty, 1, 2, or 3 guilty, not guilty. This is solely your decision. As jurors, you are the trier of the facts of the case. At this time, I will now give the verdict forms to Madam Clerk, and I'm going to ask the jury to retire to your jury room. I would ask that you not begin deliberations until I tell you that it's okay to do so through the clerk. Okay? Thank you very much. Now, maybe excuse me.
Our name on this. She never the question. I mean, ain't no way. How they gonna get? Okay. How they gonna get a whole glove through that? It might have been
Is it 2 gloves? Oh,
2 gloves.
It's 2 gloves.
Yep.
I thought
And they
said
both got
one was
red.
hanging out.
One is no, like here. You must have look at that paper.
Pass it out.
Say little make sure.
Yeah. She been. Even last night, we were watching that color. Her friends could have set her up. Her friends could have. Oh yeah, her friends could have set her up. Yo, her friends could have set her up when she left the house. Because the door there, she didn't have a bed. Then how did she do it? Her friends could have set her up. How her mama know when? She probably sneaked out the window when her friend was sleeping. When Faye was sleeping. I believe it.
Right. That kids don't have to sneak out, bro.
Did she kill somebody? It's an old house.
There is a chance she could have
Did you listen? She apparently vandalized. Y'all, why they still got big idea?
Well, as a property, who thinks is good, not guilty?
But look, they don't got their fingerprints.
I feel like the burglary.
Yeah, they said
That's a little.
Because they stopped talking about the burglary part.
Right.
So it's giving not Listen. But how did you know she went in there? They got her fingerprints. They could have got her fingerprints in their glove. So they really didn't look for her. It's giving not guilty.
Wait, where's your
That's not guilty. It's giving not guilty. Because she could have got her fingerprints. No, for the, this one. You think not guilty? Yo, Kylie for that.
You think not
But the mama.
I don't know.
Kylie, what do you think? She said guilty. But I'm telling We gotta wait.
It's most people that are guilty. We gotta wait for her.
If we don't got people,
If we don't got
we don't have to go to the people that got the most not guilty or most guilty.
Nah, for real, cause like
We not trying to be.
we can't redo it. It's big, no, but everybody put not guilty.
Have they tried like putting your clothes in like your
I
friends?
don't look, they're not guilty because they found
That would make sense. Cause
They
like,
found, and it was 2 people, so. Yeah, and it was 2 people. And other people could have it for other persons. But then listen, hear me out. Other people could have initials PM. It can't just be Peyton McKenzie.
Right, that's what I wanted them to say. I wanted them to
You
say.
signed up to you.
I wanted them to say, oh my bad, you go, my bad, go.
Other people could have other like initials like because
Yeah, it's a lot of students.
They could have got it fingerprint
I was
from
waiting for,
Listen,
that should have been one of their questions. Like, who other in the school initials are PM?
Oh, right.
but listen, if she knows that if she did it, let's say if she did, why would she put it in the locker room if they know
so that's stupid and you know she's smart.
Exactly. So she's not guilty.
She's smart.
She's smart. She said she's smart.
Then she said, yeah, that's you say not guilty with the first one?
I don't believe that she, that's why I don't believe that she
Not
got
guilty with the first one.
You wouldn't take the glove with
Like, she gotta open that junk. Okay, she gotta open that junk every day. Ain't no way she got it.
Wait. It didn't say that.
she could be guilty of something.
I think it's or.
It's really hard. I ain't gonna lie.
They both got.
So y'all telling me this? So do they have cameras? I want to know friends name. Wait, it was
It was Morgan
And they said
something.
that anybody
Morgan
can get to the
something.
file. What you about to read? So it could with the he about to
It was Morgan.
Be quiet.
Making noise.
Has to count to burglary.
Bro, be quiet. Y'all can hear. Who's trying to read?
S2 second count, burglary second degree.
I don't.
Burglary.
Second degree.
Burglary means steal.
No, break it.
Yeah, break
Like breaking.
Oh, that means breaking in, but not
It's
stealing
not
nothing.
guilty because they said this. She don't got no thing to enter the school, and then they said the security is bad.
Wait,
and all
it
they do
wouldn't
is
be
open
bad.
it. So how would she break in?
Exactly.
She just opened the door.
I said, raise your hand for not guilty.
For burglary? I don't think she
Could just open the door.
Because the doors are unlocked.
That's
Not
not
guilty.
burglary.
Anybody could have did
But
it.
if she did,
Okay, for real.
everybody say not guilty.
Yeah, for burglary.
If we
not
wrong, oh well, it should be not guilty.
There is no right or wrong answer.
guilty. Like, don't be right to us.
It's up to us. There is no right or wrong answer. It's up to us.
God, no, you heard me.
This is
I'm just kidding. I'm so nice. Really not getting bad. Okay, it says as the count 3, computer crime to in the second degree.
But we don't know if she did it or not.
Can you say it again? I got something to say.
She said,
Computer crime in the second degree.
yeah, but if she didn't have no gloves on for the computer, they should have found her DNA automatic.
Right.
So
It's either the what's the boy name? The detective. He not looking and he just a little.
and they got cameras in the school.
That's what I
Oh,
Why can't we just take the cameras to see?
I don't think
So
so.
how would they raise your hand for not guilty?
James, how
Bro,
They not really making sense.
Hey, Malachi. Come on, Malachi. What you think?
Bro.
yo, bro.
like it has.
If there's cameras, so if they look at the camera, they would see her.
They should have.
Right. Every school got cameras.
And the flashlight you can see.
If they say it's too, if they say like class if they say it's too dark, so they can't check the camera.
But the mom never
Hey, ain't most of the cameras got lights.
Because you can do it way later.
It should.
It could be a crime because they're because they're It can be a crime in 2013 and not just now doing it.
But why is it a crime in 2025 and in 2026?
Because she probably has a warrant on it.
Yeah, they probably like was doing like blah 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 blah.
Or
Then
she
they
probably
just
didn't
now
have a.
coming to court.
Or she probably did have like
So
somebody to help her.
Knock on the door. We're done. Stop it. She probably had to find her. Stop it. She's probably her cooking baby.
Guys, can I speak for a second? They said there was 2 students coming out of that room. They didn't read. It's all that means.
And they didn't bother to look for the rest of the
Other girls in this room could also be peeing out.
Y'all ready? We done. Y'all ready? Yeah.
Wait, what?
Just not get a third time. We all done. All of us not guilty. Alright, listen. If we get wrong, oh well. It's not gonna get no wrong.
All right, all the jurors are back and accounted for. Has the jury been able to reach a verdict in this case? Is that right? If you would please hand to Ms. Morrison, our clerk, the jury forms. Ms. McKenzie, if you would please stand. All right, this is against State of South Carolina versus Peyton McKenzie. The jury has returned their verdict forms to me. Everything appears to be in order. The foreperson, Mr. Chavis, has signed the forms. I will now publish the verdict. On count A, we, the jury, impaneled and sworn the above titled cause, do upon our oaths as follows. Is to count 1, entering public building for purposes of destroying records or other property. The defendant is not guilty. As to verdict form 2, we, the jury, impaneled and sworn in the above titled cause, do upon our oaths find as follows. As to count 2, burglary 2nd degree, defendant is not guilty. As to count 3, we, the jury, impaneled and sworn in the above titled cause, do upon our oaths find as follows. As to count 3, computer crime in the 2nd degree, defendant is not guilty. Order in court, please. Jurors, you have reached a decision. Has your decision been unanimous in all counts?
Use your words.
Yes, sir.
All right. Ms. McKenzie, congratulations to you. Through the work of your lawyers and everything that's been done, you are free, and you are free to leave whenever you choose to. You are not guilty of these charges. Congratulations. I'll tell you this, and I was going to take some questions before the jury went out, but I wanted them to be here as well. I too have a 5th grader, and my 5th grader is a Brennan Bulldog, so not too far away from y'all. And for the last probably 2 weeks, I've been in my truck. I've had this big packet of information that Deputy McFarland, and as you can see, I've made notes and written on it and tried to be almost as prepared as y'all were. But it's remarkable to me to see the work that y'all were able to do in this period of time. To the prosecution, I would tell you this. The system is designed in such a way that you're not supposed to lose, and it's really not a win-loss situation. But in a criminal trial, the burden is way up here, okay? Because you have somebody's life, liberty at stake. And so it's supposed to be very, very hard for y'all to get a verdict of guilty. That's the way it's designed. If it were a civil case, which is kind of beyond the scope of what we're here for today, but if it was some kind of case other than criminal case, y'all would have a lot easier time in what you were trying to do. But the system is designed in such a way that it makes it really hard, or it's supposed to make it hard, for y'all to have a verdict of guilty because of the burden of proof. And that burden of proof is you have to leave those jurors firmly convinced of this person's guilt or innocence. And typically in this situation, it's hard to do. To the defense, I would tell you this. Y'all did a remarkable job, just as the prosecution did. When you're dealing with somebody's life and you are tasked with an unbelievable responsibility, because in the real world, and we tried to make this kind of a real world scenario, you're sitting there with your client and there's a real chance that these people who you've never laid eyes on before, who in a real trial you would have picked out of a pool of probably 100 people, they come in and they have to decide based on what everybody does, and in large part based on what y'all do, whether or not your client gets to go home tonight. And that's a really big deal. And that's why that burden of proof is so high. And because of y'all's hard work, Ms. McKenzie gets to go home. And so that's a big deal too. So what I'd like to know is, without giving away too much information, I'd like for y'all, and it can be through the foreperson or it can be through other jurors, one at a time, what was it that really kind of gave y'all the belief that Ms. McKenzie did not commit any of these crimes? What was it for y'all? Was it more so? Yes, ma'am.
I believe that she did not commit the crime.
I'll repeat what you said. Go ahead.
I believe that she did not commit the crime due to how thin those gloves were. They could easily fit through the little locker slot, so she could be framed easily.
So basically, it's interesting because what I found is typically jurors will pick up on something very small that some other people may just go way over their head or may not think about. But what she said is that the gloves, that remember at the very beginning, we had a motion that y'all didn't even get to be a part of as to whether or not I was going to even allow the gloves to come into evidence, and I did. But in this situation, she said that one of the reasons why they found Ms. McKenzie not guilty was because the gloves were very, very thin, and the gloves could have been slid into the locker, essentially, potentially framing her or being somebody else's gloves. So that was something that was picked up on by these very acute jurors. What else? Yes, sir.
Also, when they said the doors are always unlocked, how can that be a burglary if the doors are unlocked? They did not break into them.
So one of the things that was mentioned by one of the jurors is that the doors, there was very lax security. The doors were not locked. So essentially, how could they break into something that was open? And that's a good point. That's a very good point. You can still have a burglary with an unlocked door, but in this case, you picked up on the fact that, well, it wasn't locked, so how was that a burglary? That's very fair. That's, again, you're the judge of the facts, and that's one of the facts that you considered to be in play here. That's one of the reasons why you found her not guilty. Yes?
Another thing that I found out kind of weird is she had a flashlight and the school has cameras, so you can see her on the camera, or the flashlight will kind of show her.
So that one was, there was a flashlight. The school should have cameras there to be able to pick up on that information. Didn't hear any testimony or evidence about any cameras really too much. But yeah, that's a point that y'all thought about, you deliberated upon. Obviously you would say that, wait a minute, if the prosecution would have come in here and they would have said, look at her, everybody, she's walking down the hallways with a flashlight, she's putting these gloves inside the locker, and then we see her destroying the computer room, well, obviously that makes it more likely that she may be guilty, right? But we didn't hear that. We didn't have that, so you have to base it on what you heard, and what you heard was nothing along those lines, and that's one of the reasons why you found her not guilty, right? Anything else? You got one? Ask it. It'll be a good question.
So, I think there wasn't that much evidence.
Wasn't? Like you were looking for some fingerprints and some DNA and all that kind of stuff? And that's what jurors a lot of times think now.
Also, the flashlight, I felt like it could have been easily framed, and yeah.
Good, very good. I'll take two more. Last two, yeah.
There was no DNA on
There's no DNA or no fingerprints, and that's one thing that I'll get you. That's one thing that a lot of times when you're watching TV and you see those things, and it's a little bit different when you get into an actual courtroom, but a lot of times jurors do say, well, wait a minute, if you had gloves, if you had, maybe one of them had some blood on it, whatever it may have been, well, there should be some evidence there, and you didn't hear any of that. So that's a very good observation that you picked up on. Last one, yes?
I know what you just said. I was going to say, if she had gloves on, there should be DNA in the gloves.
If she had gloves on, there should be DNA in the gloves, and we didn't have any testimony. While that may have, and I think that the investigator testified that there were gloves, but no other tests were done or anything like that. So obviously your question would be, wait a minute, this person's facing a whole bunch of time, possibly if she gets convicted, and we need to know for sure that it's her, and y'all didn't know for sure, right? And that, ladies and gentlemen, is how the system is supposed to work. Because y'all were not 100% sure, you weren't firmly convinced that this particular individual committed the crime, so y'all found her not guilty. And so I commend you on what you did. You did a very good job. Y'all were very astute. That means that y'all were listening to everything. I think that y'all paid attention. You paid careful attention. So very good job there. Counsel, again, I commend you on everything that y'all have done. You did a remarkable job. I tell people all the time, one of the hardest things to do, one of the biggest fears that people have is speaking in public. It's hard. It's not easy. And y'all stepped up to the plate. Y'all were the ones that got up in front of everybody. This courtroom's filled with people, and y'all did a remarkable job, all of you. And so you should be commended for what you did. I'll give you a big round of applause.